My name is Kim Talus. I'm the professor of energy law and the director of Tulane Energy Law Center in New Orleans, United States. I'm also a professor of European energy law at University of Helsinki and professor of European economic and energy law at UEF Law School in University of Eastern Finland. Now, what I'll talk about today for about half an hour are the latest developments on the amendment to the EU Gas Market Directive and its extension to external pipelines. I'll talk about roughly 30 minutes and then we have another half an hour for discussion. And if you write questions or comments to the Q&A section, I'll then comment on those questions. Now, I have provided legal opinions for Nord Stream 2 in relation to this amendment. Most, if not all, of my suggestions or opinions have subsequently been confirmed by either Commission Legal Service or Council Legal Service. So far, I'm happy with what I've said. Let's see what happens now. So, I'll just figure out how to use this. Yes, so the amendment to the Gas Market Directive cannot really be separated from Nord Stream 2 gas pipeline. Because if we look at the background to the amendments and different steps, we'll see that they relate to one single pipeline. And I've had a first webinar about half a year ago on these issues, and I'll repeat some of my findings first here before I move then to the details of the amendment. So, as a first step, European Commission suggested that the Gas Market Directive is applicable to Nord Stream 2 pipeline. My assumption is that the intention was to complicate, if not prevent, the pipeline project. Now, most commentators, or all academic commentators, and Commission Legal Service eventually found that this claim was not founded. And in fact, the Gas Market Directive was not applicable to external pipelines. Also, it had never been applied to external pipelines before, and so the arguments of the Commission were largely then refuted. So as a second step then, Commission asked the member states for the right to negotiate an intergovernmental agreement between EU and Russia, and that would cover Nord Stream 2 and would be based on the principles of EU energy law, whatever those are, third-party access, unbundling, and these type of provisions, I would have to assume. The argument was that, I see that somebody has a problem with streaming. I'm hoping that's not a general problem. Nevertheless, the argument of the Commission was that there is a need for an intergovernmental agreement because there is a gap in the law, a legal void, and or a conflict of laws. Now, the Council Legal Service provided an opinion on this issue and concluded that an intergovernmental agreement was not necessary. It remained an option if parties so want. And of course, these IGAs are commonly concluded for gas pipelines in order to support the pipeline projects. But that there was no legal requirement. For the legal void argument, the Council concluded that there is no legal void because international law, European law, and the law of the relevant member states apply to the pipeline. It was just a question that the Gas Market Directive was not intended to apply, but that did not translate into a legal void. For the conflict of laws situation, the Council Legal Service concluded that there is no conflict in laws. The applicability of Russian law ends to the Russian territory, and then applicability of EU energy law starts at the first connection to the EU internal market. So there was no conflict of laws. My understanding is that this request to negotiate an intergovernmental agreement was never lifted, so it still exists. But without dropping this request, the Commission then quite suddenly and surprisingly came out with the idea of amending the Gas Market Directive so that it would then be applicable to pipelines that are external to the EU internal market. Now, as a background still, the necessity for this amendment, the text itself says that it's necessary because of completion of the internal market and then security of supply reasons. Now, I'm not going to go through all the arguments and all the relevant facts here, but it was a little bit surprising to have these as the reasons for the extension of the rules. Because first of all, the markets work actually better than they have ever before. They are much more interlinked than they are ever before. So gas can actually move quite well from north to south, from west to east, east to west, and so on and so forth. We have access to markets which is more diversified than ever. We have LNG facilities, we have several pipelines, we have upstream pipelines bringing gas from countries like Norway. And so the access to the markets is highly diversified today. Of course, the relevant question, or the interesting legal question to me, is that why are these different methods of importing gas to EU treated differently under the Gas Market Directive? But that's a separate point. The gas is more and more traded through hubs. Hub pricing is also linked to long-term contract prices, and the Gazprom settlement from last year extends the hub pricing to many other areas that are not served directly by a hub. So the ability of a company like Gazprom, or primarily I guess Gazprom, to exercise market power in Eastern European countries has been reduced significantly. And maybe the most surprising element has been that there has been no discussion about these security of supply problems or completion of internal market issues in relation to external pipelines or their operational details prior to September 2017. So this is really, and I think member states and the European legislator is well aware and knows that this is about one single pipeline. But it also appears, because the impact is wider than just a single pipeline, it appears that member states agree to take the collateral damage that comes with the amendment, both in terms of control of external pipelines moving to EU level, in terms of competence, and then the risk these new rules reflect to or create to existing pipelines. But, oh well, I'll try to read your comments a little bit afterwards. The last thing I want to say as a background is that this is a significant change to what we had before. EU energy law has never been applied to external pipelines. We have several external pipelines in the Mediterranean where EU energy law has not been applied, and that is about to change to a certain extent. And because this is such a significant change, was too bad that no impact assessment was ever, at least to my knowledge, carried out. This should have been done, because to me a significant change like this would require that you understand what happens when you do these changes. But now to the details of the amendment. Oh, sorry, one more slide of the background. The November 2017 was the date, or was the month when the European Commission came out with its proposal 2018 was basically different versions, different revisions came out, they were negotiated by the member states, but nothing really happened. Romania took the EU presidency in 1st of January, and only 2-3 days later they tabled the first revision, received some comments, and a month later, February 4, there was a legislative text for Coreper's vote. 3 days later, Germany and France reached a compromise about the text, which stated that the rules of the internal market should be applied in the territory and the territorial sea of the member state where the first interconnection point with the member state's network is located. Next day, all but one member state accepted the compromise. So Coreper accepted the compromise. 4 days later, the trilogue accepted the compromise, and that is now reflected in the text of the amendment. A week ago, 20th February, Coreper then endorsed the provisional agreement by the trilogue. And now to the details. Now, the most important amendment, or the most important change, is the definition of an interconnector. From a legislative drafting technique, it is interesting to change the scope of the directive by changing the definition of an interconnector, because in fact interconnector is only mentioned in the context of a merchant exemption under Article 36, but this was used to change the territorial scope of the directive. Perhaps not the best way of doing it, but done nevertheless. So the new wording for an interconnector is that it means a transmission line which crosses or spans the border between member states for the purpose of connecting the national transmission system of those countries, which was what we had before. And it added transmission line between member state and a third country up to the territory of the member state or the territorial sea of the member state. Now, this is further clarified in recital 5 of the amendment, which states that the applicability of the directive to gas transmission lines to and from third countries remains confined to the territory of the member states. As regards of offshore gas transmission lines, it should be applicable in the territorial sea of the member state where the first interconnection point with the member state's network is located. So what does that mean? It means that the scope of the directive is extended to the territorial sea of the member state where the first interconnection point is located. This has a number of benefits. First of all, it eliminates the violation of United Nations Law of the Sea Convention. So it excludes exclusive economic zones, and it also excludes the problems coming from multiple regulatory authorities applying the rules for their own small sections of the same pipeline. So, in other words, the applicability of EU energy law has been extended 12 nautical miles, which is roughly 22 kilometers. And in practice, this means that we need to create a virtual entry point to the border of the territorial sea of the member state where that first interconnection takes place. Beyond that, or beyond that virtual entry point, or if we look at it towards Europe or towards EU, after that we start to apply EU energy law to the pipeline. But the long section, going through the EEZs all the way to the Russian border, if we talk about Nord Stream, then is without application of EU energy law. Now, there are other sections as well, or other articles that were changed. One of them is Article 36, which is the merchant connection, or merchant exemption, which states that, well, in one of the requirements, that the exemption must not be detrimental to competition in the relevant markets which are likely to be affected by the investment. Now, there's also then paragraph 3 that talks about a obligation to consult the national regulatory authorities in those member states of which the markets are likely to be affected by the new infrastructure. The question is, what does this mean? Who are these affected states? My reading of this is that those affected states are not the states through which the pipeline goes through or through which territorial sea the pipeline, exclusive economic zone or territorial sea, the pipeline goes through, but rather they are those member states that are affected by the supply of gas through this new infrastructure. One of the issues here is that because we have an interlinked market, there is going to be some degree of affectation to many of the EU markets or EU member state markets. So I think in practice we have to have some sort of de minimis rule on the affectation. But then again, this is only an obligation to consult. So if there is some degree of ambiguity of which these member states are, it is an obligation to consult, nothing more than that. The next article, that is a brand new article, is significant. It provides for a possibility for member states to derogate or provide derogations for existing pipelines. Under the article, transmissions line between member states and a third country it is completed before the entry into force of the directive may be derogated. It may provide derogation from articles relating to unbundling, third-party access, and so on and so forth, for reasons such as enabling the recovery of investment made or due to reasons of security of supply. And then there are requirements on cannot be detrimental to competition, effective functioning of the market, and security of supply. Derogation should be limited to 20 years based on objective justification. It may also be then how do you say that? Renewed, sorry. So what does this mean? First of all, it only applies to those interconnectors that have been completed before the entry into force of the directive. I will come back to this, and this relates now specifically to Nord Stream 2, because it is the only pipeline that is ongoing at the moment of the project is ongoing, and it doesn't seem to fall under this provision. Now in this context, we need to remember that the money or the capital invested in a pipeline like Nord Stream could be much larger than it is to a completely completed old pipeline. So, but I'll come back to that in more detail. It also means that the duration of the exemption cannot be 20 years full stop and renewable. It means that the duration of the derogation needs to be connected with the investment recovery and security of supply. Now, security of supply is a vague notion, as everybody will appreciate. And investment recovery, again, means that existing pipelines should not enjoy a 20-year derogation, because in those cases, unless they're very recent, if they have been constructed in the 80s, 90s, the initial investments have been recovered already. So 20 years should not be an option. But then the practice will show. There is a peculiar statement at paragraph 4, which talks about other concerned member states. So again, the member states authority, whatever that is, needs to consult with concerned member states. There is no clear rule on who these concerned member states are. Are they those member states through which the transmission line flows, or is it something else? But again, this is an obligation to consult. So this ambiguity again is not maybe the end of the world. What does this mean for decisions over external import pipelines. In essence, the control of these pipelines moves to EU level. For Article 36, it's been extended to these import pipelines, means that the Commission, which has the final say over these exemptions, can then decide whether or not a pipeline is granted an exemption. And because most of these new pipelines will be built under exemption, this is both my personal opinion because they have high risk profiles, and also it's noted in one of the recitals of the Gas Market Directive as the assumption of the legislator. Commission has effective then control over future pipelines. For the derogations, the control is at national level, but of course it was conditioned by security of supply and so on and so forth. It has a requirement that it cannot be detrimental to competition, it cannot harm security of supply. So if the European Commission feels that a member state has given a derogation which is too beneficial, it may then initiate infringement proceedings, and therefore in the end the court would decide, but the EU level takes the control over these pipelines. This is not the case today, of course. So the question is, what does that mean for the national energy rights? The structure of supply and choices between energy sources that are protected under Article 194 of the Treaty on the Function of the European Union. Let's say that there is a tension between these national energy rights and the fact that the control over external pipelines moves to EU level. Intergovernmental agreements, there is a new article 49AA, which is an empowerment article, relates to intergovernmental agreements. The first point is that these intergovernmental agreements should not be necessary because the situation is essentially the same as we had today. There is no legal void, there is no conflict of laws. The applicability of EU energy law is just extended 12 nautical miles. But where a new or existing IGA would have to be negotiated or renegotiated, and when they would fall under exclusive competence, there is an empowerment article for this. Now the empowerment, like all the other empowerment regulations that we have for bilateral investment treaties or investment treaties generally, for example, Commission has full control over the negotiations. They give the right to negotiate and they accept the final version. And the Article 49AA also notes that these IGAs cannot be in conflict with EU law, and because EU law includes both general EU law and then sector-specific regulation, like the Directive for Gas, regulation and network codes, there cannot be a conflict between an IGA and those instruments. There was also a new Article 48A that deals with transmission system operators and their freedom to maintain, enforce, or conclude technical agreements on issues concerning operational details, let's say. Now, there is the same issue as with the IGA. These technical agreements, it's unclear what they precisely are, but maybe that's not a big point. But there is an obligation to renegotiate these when they conflict with EU law, including EU gas market regulation, and they cannot conflict EU law. So, in essence, nothing in this provision helps a situation where you have a conflict you need to renegotiate. Especially, I guess, network codes would be the relevant instruments to have a look at in this situation. Now, there were exemptions from the scope. Obviously, member states with no connection to third countries does not have to comply with the amendment. And then Cyprus and Malta do not have to comply until they have infrastructures connecting them with third countries including upstream pipelines. And given the developments in the Eastern Mediterranean Sea, or Eastern Mediterranean generally, yes, this provision or this trigger might become relevant for Cyprus at some point in time. Now, compared to the Commission original proposal, this is an improved version. But the problems I've already noted, or the, let's say, weird or ambiguous notions are there. And in addition, we do have certain problems from international law or European law perspective. The first one is really the Article 49.9, the derogation. It is not available for those pipelines that have not been completed. Now, of course, I can understand why this is the case. It is created to complicate Nord Stream 2 project, and by saying not completed instead of, for example, final investment decision, which would, from my perspective, be more logical, you can then eliminate Nord Stream 2 from the scope of the derogation. And to me, it appears that also the exemption under Article 36 is complicated for Nord Stream 2 because it has already made the final investment decision. So it's conveniently the only pipeline that cannot enjoy an exemption nor a derogation. But in that particular project, there are significant amounts of money already invested before it's completed, even before we knew that the directive would be modified or amended. So to me, the question of legal certainty and protection of legitimate expectations and discrimination are relevant here, because the legislative proposal came very suddenly, and it is now applied retroactively to a project where the final investment decision has been made in a different regulatory environment and significant amount of capital has been invested. So it certainly raises issues of general principles of EU law. WTO compliance and the question of discrimination under WTO system is relevant because of the Russia-EU panel report from fall 2018. In that report, the panel found, it is obviously subject to appeal at the moment, but the panel found that measures that treat gas from Russian origin or from a origin less favorably than the others falls under discrimination. And with that, they found certain EU measures to be problematic. And I think this new amendment, given that it targets one single infrastructure, falls under that category. Also, discrimination under the Energy Charter Treaty is an issue. And then, especially if you look at the whole, let's say, Gazprom or Nord Stream 2 saga, from the claim that a directive applies to the IGA and to the amendment, the question of fair and equitable treatment under the Energy Charter is also relevant. So with that, I think I'm running out of time for this section.